Welcome to SCOTUScast, Drunk Driving, Chemical Tests, and the Fourth Amendment Edition. Thank you for tuning in. On April 20th, 2016, the Supreme Court heard oral argument in Bernard v. Minnesota, which was consolidated with Birchfield v. North Dakota and Beylund v. Levi. In Bernard, William Robert Bernard Jr. admitted he had been drinking, but he denied driving his truck and refused to perform a field sobriety test. He was arrested on suspicion of driving while impaired and taken to the police station, where he refused to consent to a chemical test in violation of Minnesota state law. Bernard was charged with 2 counts of first-degree test refusal pursuant to state law. In Birchfield, Danny Birchfield was arrested after failing field sobriety tests after he had driven his vehicle into a ditch, but he refused to consent to a chemical test, resulting in a misdemeanor charge. He moved to dismiss the charge and claimed that the state law in question violated his Fourth Amendment right against unreasonable search and seizure. In Beylund, Steve Beylund consented to a blood alcohol test to confirm he was driving under the influence, but only after being informed it was a criminal offense to refuse a blood alcohol test in North Dakota. The test confirmed he was over the legal limit, and Beylund was charged with driving under the influence. The men in these cases challenged state statutes criminalizing refusal to submit to a chemical test, arguing among other things that the statutes violated the Fourth Amendment. The Supreme Court of Minnesota and the Supreme Court of North Dakota rejected their respective challenges. The question before the U.S. Supreme Court in these consolidated cases is whether, in the absence of a warrant, a state may make it a crime for a person to refuse to take a chemical test to detect the presence of alcohol in the person's blood. To discuss the case, we have Jonathan Ellis, who is an associate at Latham and Watkins. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker. And now, Mr. Ellis.
First, a disclaimer. I filed an amicus brief in this case on behalf of the Council of State Governments and a group of organizations that represent the interests of state and local governments. Any opinions I express on this podcast should be taken, however, as my own. They don't represent the views of my clients or my law firm. And there are a couple interesting aspects about this collection of cases. On the one hand, the issues in these cases are among the most accessible issues before the court this term. Everyone drives, or at least almost everyone drives. Sadly, almost everyone has had their life affected by drunk driving. And even the legal test in this case, at least the text of the legal test, whether a police conduct is quote-unquote reasonable under the Fourth Amendment, is a test that everyone feels like they can opine on, that they can have an informed view. Now, on the other hand, the court, as courts are wont to do, is taken that straightforward legal test and developed 25 or so doctrines for evaluating when police conduct is reasonable in any particular circumstance. The argument in this case demonstrated both aspects of the questions here. It began with Charles Rothford standing up, representing all of the individuals in these cases, challenging the implied consent laws and the criminal penalties attached to those laws in the states of Minnesota and North Dakota. His argument began with a series of doctrinal questions of the kind that you would expect from reading the briefs and from being in the Supreme Court. Justice Kennedy wanted to know the difference from a doctrinal perspective of imposing a criminal penalty for refusing to abide by these implied consent laws and imposing a civil penalty, that is taking away a license, he said. Isn't taking away a license for 2 years a civil penalty, one that Mr. Rothfeld didn't challenge, worse in some ways than imposing a minor criminal penalty, say 3 days in prison? And why did that make a difference under the court's cases? Justice Alito, Chief Justice Roberts weighed in with questions about consent and about the extent of a state's authority to condition consent on the use of a privilege like driving. And Justice Sotomayor weighed in on her own view as to the distinction between criminal and civil penalties and made it very clear that she believes there is a difference and that the criminal penalties go beyond what the court's cases allow. About 15 minutes into the argument, however, things changed for the first time. That's when Justice Breyer weighed in with a question he thought wasn't adequately addressed in the briefs. He said, look, there are 2 types of tests at issue in this case. Now, there are actually 3, but He focused, I think, on only two. There's the blood test, the drawing of blood from an individual, and the penalties that come with refusing to allow that. And there's the breathalyzer test, right? That blowing into a tube and the penalties that come with that. And he said, what? Aren't those two fundamentally different tests? Isn't the invasiveness of a blood test much, much more than the invasiveness of a breath test? And why doesn't that change the analysis fundamentally for these two tests? And for the rest of Mr. Rothfield's time at the podium, that is the distinction on which the court focused. And in perhaps a way that doesn't favor Mr. Rothfield's clients, the questions on that distinction came from the more liberal justices on the court, the ones that he probably hoped would be on his side for both types of tests. And in the process of that questioning, several different doctrines came up. The whack-a-mole game began. And so, Chief Justice Justice Alito had asked questions about consent and about the unconstitutional conditions doctrine, that is, the ability to condition consent on the use of a privilege. Justice Sotomayor hinted at the special needs doctrine, a doctrine that allows police officers and governments to conduct programmatic searches where there's a compelling need to do so without a warrant. Justice Kagan brought up the search incident arrest doctrine. That is a doctrine that allows police officers to perform certain searches of a person after they've arrested that person to preserve evidence of any wrongdoing. And Justice Breyer brought up the idea of a Terry stop. That is the doctrine that allows a police officer to stop an individual on the side of the road with just a reasonable level of suspicion in order to and perform a brief search in order to figure out if something is amiss, something more criminal is going on. When Mr. Rothfield sat down, what was clear was that the court was struggling with this question and was considering the question from both sides, and seemed open to finding a way to allow the state to punish at least the refusal to offer a breath test. When Mr. McCarthy got up, Thomas McCarthy stood up for North Dakota, his argument started in a typical way as well. The Chief Justice asked a question, a hypothetical question. What if the state had passed the same law, except instead of a breathalyzer test or a blood test, it required that drivers consent to allowing a test of their cell phone? This is a hypothetical that is altogether unexpected from the Chief Justice. Just a couple years ago, he had written a unanimous opinion in which he said searching a cell phone, the contents of a cell phone, is not permitted by the search incident arrest doctrine because of the data and the intrusiveness on the phone, the intrusiveness of allowing the government to get to that data. Mr. McCarthy struggled a bit to find his footing at the beginning of his argument, but eventually landed on an answer that distinguished the cell phone search from the breathalyzer or blood test based on the level of intrusion into someone's life, and the kind of information you get from a cell phone, and the need to capture alcohol evidence as it dissipates quickly in a way that doesn't apply to the data on a cell phone. After that exchange, however, again, the argument took a different turn. And for the remainder of Mr. McCarthy's time at the podium, and for the entire extent of Catherine Kinna's time at the podium on behalf of Minnesota, the court focused on the practicalities of this law. They wanted to know how many magistrates and judges were available in Minnesota and North Dakota. They wanted to know how long it would take to get a warrant over the phone in those jurisdictions. They wanted to know how many blood alcohol tests were performed in a given year. And they wanted to know what were the state's interests in avoiding seeking a warrant, in allowing and seeking this consent instead of a warrant, even where it might not take an extended period to get a warrant instead. Mr. McCarthy gave the statistics that he could, gave the answers that he could on the practical question, but consistently tried to steer the court back to doctrine to no avail. Ms. Kinna's time at the podium was also spent almost entirely on the practicalities of these laws. In fact, two important aspects of her argument. The first was the revelation that, at least in Minnesota, breathalyzers typically take place at a police station, not on the side of the road. It was clear from the argument that this was a surprise to several justices. At least Justice Sotomayor, Justice Breyer, and Justice Kennedy each asked follow-up questions to confirm that they understood Ms. Kenna's statement correctly, and Ms. Kenna confirmed that it was true. The second aspect, noteworthy aspect of her argument, was how it ended. There was an exchange between Justice Sotomayor and Ms. Kenna, in which it seemed that Ms. Kenna wasn't quite sure that Justice Sotomayor had asked a question. There was an awkward pause, and then Justice Alito spoke up to clarify. He said to the advocate, "Justice Sotomayor is assuming that you're going to lose, so she wants to know what your reaction is." Ms. Kenna ended her time at the podium by saying, "Well, I don't like it. I don't like it one bit." And she sat down. Mr. Gershengorn then stood up on behalf of the United States. The United States isn't a party to this case, but had filed an amicus brief in support of the states. And so, as according with court tradition, Mr. Gershengorn had 10 minutes to express the United States' views. In those 10 minutes, he tried to address the things that seemed to be concerning the justices. He explained that warrants aren't always available 24/7 in every jurisdiction in the country. He explained that sometimes it can take up to 2 hours to get one of those warrants, even when they are available, all the time while alcohol is dissipating from the driver's blood and perhaps eventually lost forever. He explained that restricting penalties for refusing to comply with valid conditions couldn't possibly be restricted to only taking away the benefit. For one, he explained, some conditions last longer than the benefit. And so, such that taking away the benefit after it's no longer there can't possibly erase the incentive for the individual to follow the condition. The court offered some follow-up questions about whether that was true in this case, but otherwise accepted Mr. Gershengorn's arguments. When Mr. Rothfeld stood up for reply, he focused on two things. One, undermining the statistics that Mr. Gershengorn had offered about the availability and the workability of seeking a warrant in every case. And his view, Mr. Rothfeld's view that is, that the intrusion represented by a breath test, even if not as intrusive as a blood test, was significant. And was significant enough that the court or that states should not have the freedom to impose penalties, criminal penalties, on a person's refusal to take that test. So at the end of the day, what seems clear is that many members of the court are more troubled by criminal penalties for refusal to take a blood test than a breath test. Justice Sotomayor, the author of the court's opinion in McNeely, which rejected the state's argument that the exigencies of the situation always allow a blood test for drunk driving without a warrant. Justice Sotomayor, the author of that opinion, seemed most troubled by the idea that the state could just take the same test that she had rejected in McNeely by implying consent from every driver and punishing that with criminal penalties. Several other justices, though, expressed concern with this approach as well. On the other hand, the court seemed open to finding a way to upholding the state's ability to punish the refusal to take a breathalyzer test. I guess the question we're left with is whether this revelation from Ms. McKenna's argument that breathalyzers often take place, maybe typically take place at a police station instead of the side of the road, is sufficient to change those justices' views coming into the argument, or apparent views. It's getting towards the end of June, so we're likely to find that out very soon.
Thank you for listening to this episode of SCOTUScast. For more episodes of SCOTUScast, as well as audio and video of past Federalist Society events, please visit our website at www.federalistsociety.org/multimedia.